South Bank Hotel Management Company Limited and Galliard Hotels Limited and others.
Mr. Willen.
My lords, my lady, I appear with Mr. Paul Gadiri, who sits behind me, my learned friends Mr. Trumpeter, King's Counsel, and Mr. McLaughlin for the respondents. You will have had, I think, some correspondence about timetables.
Actually, we haven't. I suspect you were only asked yesterday for a timetable, were you?
Yes.
But given that there's quite a lot to pack in, we thought it was a good idea to have a timetable.
Yes. Unfortunately, we don't have an agreed one. I don't think either of us want to spend time on it.
No.
But the difference between us is this. I would prefer to deal with the grounds of appeal and the respondent's notice together, which effectively means I'd be on my feet for today, my learned friend tomorrow, and then the final day for replies. My learned friend would like to run it as a back-to-back appeal and effectively a cross appeal. So we'd have me open the appeal, him reply, respond, and then me reply, and then open the respondent's notice. My view is they're so interlinked that that's going to be quite broken up. But we'll do whatever my lords and my lady would find most helpful.
Let me just hear what Mr. Trumpeter has to say.
Well, I echo that submission. Ultimately, what we want is something that the Court of Appeal is going to find most useful. It struck me that there may be some efficiency in dealing with the matter in the way I have suggested, if only because, and I'm certainly not trying to get ahead of myself, but if my lords and my lady consider, having heard arguments on the appellant's notice, we don't need to go to the respondent's notice, then obviously we don't need to hear argument on that. But ultimately, I don't want to waste time.
For us to make a decision in our own minds, at least, as to, well, at least tell you that we decided a particular point.
But as I said, ultimately, whatever is most helpful to the court is what I'm concerned with.
I think unless my colleagues think otherwise, Mr. Willen's course might be convenient, because otherwise I think we'll be chopping and changing between the different subject matters. So let's go with that. So all being well, Mr. Willen, you would hope to complete your submissions today. Yes. On the three grounds and the respondent's notice. Yes. Aspects. Okay.
I won't say very much by way of introduction. My lords and my lady will know this is an appeal effectively about the consequences of Mr. Conway implementing, through two companies that he controlled at the time, what has come to be known as the Annex Lease Scheme. And at the heart of the appeal, at least from our perspective, are two critical features. The first being the fact that the appellant, which I will call South Bank to avoid a stream of letters, had an equitable interest, we say, in the annex before Mr. Conway implemented the Annex Lease Scheme. And the second critical factor is that the Annex Lease Scheme did, as indeed was intended to, transfer the right to enjoy the annex into Lodgeshine, which is a company controlled by Mr. Conway and which was stood for the benefit of himself and his family. And consequently, we say what has happened is that Lodgeshine, and through it, Mr. Conway, is seeking to use limitation to retain, and indeed to continue to extract for the indefinite future, the benefit of his scheme in the form of rent for the annex from South Bank. There are three groups of issues on the appeal, and given that my lords and my lady will be familiar with them, I'll just identify them. The first group of issues relate to the claims for breach of Mr. Conway's fiduciary duties as sole director of South Bank in devising and carrying into effect the Annex Lease Scheme. That principally gives rise to issues relating to the meaning and effect of Section 21(1)(b) of the Limitation Act, and those are grounds of appeal 1 and respondent's notice at ground 1. There is a consequential issue, if we are right on limitation, about breach and what your ladyship should do about that. Our position is and remains that it would be appropriate to remit the question of breach, essentially because it would require a first instance determination. And by breach, I in fact cover three issues: breach, ratification, and excusal under Section 1157 of the Companies Act. But my learned friends say by their ground 1A that you can conclude that there either was no breach, it was ratified, or it should be excused, and therefore there's no need to send it back. We say that's not the right approach, but if it were appropriate for this court to form its own view, we would say you can in fact conclude that there was a breach which has not been ratified and should not be excused. The second group of issues are claims for breach of the room leases, breaches by Galliard Hotels. That is the continuing breach issue, if I can put it that way. Our ground of appeal number 2 challenges the finding that there was no continuing breach. My learned friend's respondent notice challenges the finding that there was a continuing duty. And my learned friend, Mr Borghideri, will address you on those probably at the end of the day so that I'm not up and down. The third set of issues relate to the validity of the lease and the underlease. As the court knows, the judge found that they had not in fact been properly executed as deeds because they had not in fact been signed by a director, but he concluded that they were to be treated as validly executed by virtue of the deeming provision in section 44(5) of the Companies Act. Our ground of appeal 3 says that that finding was not open to him in relation to the underlease because Lodgeshine was not a purchaser, and our ground of appeal 4 says that on both the lease and the underlease, Lodgeshine was not acting in good faith because the company knew through Mr Conway that the documents had not in fact been signed by a director. My learned friend has 2 respondents notice points, both grouped under respondents notice 3. One is that we can't run this point because of estoppel by grant, and the other is that he would invite a finding that there was valid execution in equity, sorry, not valid execution, valid effect in equity, even if not validly executed as deeds. Can I just take the key facts very briefly from the judgment? It's a long judgment, but actually what you need for the purpose of this appeal are very limited. You start off with the fact there are hundreds of investors who provided funds for the development of the Park Plaza County Hall Hotel, the development being undertaken by Galliard Hotels, which at the time was the owner of the freehold title to the site, including the annex. If you turn then to the judgment core bundle, tab 6, page 61, what I have just described about the investors paying in is covered by paragraph 4.1. At the outset, the investors enter into what is called a room contract. You don't have a copy of one of those in the bundle, but the 2 key features of that are not in issue. First, each investor was promised a lease of their particular room in due course. And second, each of the investors was promised a share in the company which was in due course to own and operate the hotel. So that is the appellant South Bank, again from a future date. Skipping on then to page 62 and subparagraph 6 of about a third of the way down the page. Part of the structure for the investment involved what is known as the freehold sale contract, the FSC. And the purpose of that contract, as the judge records, was to ensure that South Bank, so the company which was to be owned by the investors, would get full ownership of the hotel at no cost. It's actually for £1 nominal consideration, but at no cost once the development was completed and the rent guarantees had expired. And so the FSC is a contract by which Galliard Hotels promises to sell the freehold title to South Bank at a particular date in the future, which is the later of all of the rooms having been leased and the rental guarantees having expired. And that transfer is subject only to the room leases that are to be granted. And as the judge found, the effect of the FSC was to transfer the entire freehold title, including the annex, which contained the hotel's conferencing facilities. Now, perhaps of limited relevance to this appeal, but just worth noting in passing, the judge made various findings that Mr Conway did not in 2004 in fact have a view as to what was to happen to the annex. And you see that, for instance, on page 72, paragraph 52, Roman 1. The judge here is looking at the contemporaneous material as to whether or not the investors were told the annex would be in or outside their investment. And at 52.1, you can see that the judge records there isn't a consistent position. And that's because the focus of the marketing efforts was on the rooms, with the result that Mr Conway did not consider whether title to the annex would or would not pass to South Bank. And indeed, if you go on to see what's said about the rectification claim on page 106, in rejecting a claim to rectify the FSC on the basis that both South Bank and Galliard Hotels had a common intention through Mr Conway when it was executed, at paragraph 222, the judge finds that there was no express common intention, and at 223 he finds that nor was there a tacit or obvious common intention that didn't need to be expressed, and at 224 the judge finds that in fact the various indicators of a tacit common understanding are equivocal, and in some cases counterbalanced by indications that a freehold interest in the annex was to pass to South Bank. So as at 2004, in fact, Mr Conway did not have a view or a common intention as to what was to happen to the annex. But come 2008, Mr Conway decides that he would like to keep it for himself and his family, or keep the benefit of it. And without getting into the detail of that, you see the origins on page 85. Paragraph 124, the judge sets out the genesis of the Annex Lease Scheme. Now in April 2008, so most, if not all, of the investors are already subscribed. You get this memo from Mr Conway to his lawyer, Mr Phillips, where he says the annex building was always staying out of the equation as something they could occupy as an office or let. And he says in the penultimate paragraph, it transpired due to the success of the hotel, it required the conferencing. And in the final paragraph, he says the hotel now looks as if it would be trading in excess of the rental guarantee. And I wonder whether it is too late to contemplate actually rentalising the annex building back into the Park Plaza lease. So come 2008, Mr Conway's desire is to monetise for his own benefit and his family's benefit the annex. Now, by the time he puts that scheme into effect, well, let me just pause there. The judge finds, just to make this point good, at paragraph 160, page 92. He finds that, as he says he'll explain later, South Bank in fact did have a contractual right to the entire freehold interest, including the annex, and so the effect of the Annex Lease Scheme was to deprive South Bank of its economic interest in the annex for no valuable consideration. South Bank could retain the use of the annex, but it had to pay a market rent to do so, and so the overall result was a transfer of value out of South Bank and into Lodgeshine, and that is obviously right. I should say, then make the point, going over the page at 164, and this is of some significance to something that comes up later, the judge finds in the second half of that paragraph, he accepts Mr Conway's evidence that he didn't know of the freehold sale contract specifically, but he concludes that he was aware in general terms that there was a contract that would otherwise operate to transfer the whole title to the site, including the annex, and that the annex lease was intended to prevent that result. So there is no doubt that Mr Conway did this knowing that Southbank had a vested legal right to the annex and that he wanted to deprive Southbank of that right, and therefore, as the judge found, transfer value out of Southbank and into Lodgeshine as a matter of law, as a matter of the legal position. And as the judge finds, just popping back over the page to 161, in the second part of paragraph 161, he says, looked at over a broader time scale, that's reflecting the fact that the investors will get the shares in Southbank in due course. Mr Conway did obtain an overall economic benefit. Southbank would in due course be owned entirely by the investors, with the result that Mr Conway would not bear the economic cost in the reduction of Southbank's assets. However, he would retain an indirect 47.68% share in the corresponding increase to Lodgeshine's assets. And of course, that's a finding which is of considerable importance in the context of section 21(1)(b). And my lords, my lady, you know the way this was done. The Annex Lease Scheme was a combination of a lease, 999-year peppercorn lease from Galliard Hotels to Lodgeshine, coupled with a much shorter underlease at a commercial rent from Lodgeshine back to Southbank. And that achieved what Mr Conway wanted, the rentalisation, if that's a verb, of the annex. So just stepping back and using, if I can be forgiven for saying, some commercial common sense. Before the Annex Lease Scheme, Southbank has an interest, I'll come back to the nature of it, but it has an interest in the entire hotel, including the annex, which would give it the full right to enjoy the annex without cost from the completion date under the FSC. After the Annex Lease Scheme, Southbank has an interest in an almost worthless reversionary freehold at the end of a 999-year peppercorn lease, coupled with an obligation to pay under the underlease for the benefit of occupying the annex after completion of the FSC. Now, in due course, I will submit that it was self-evidently, one might say, not in the best interests of Southbank, looked at as an individual company. It had valuable legal rights. Mr Conway knew it had valuable legal rights. It gave those up for nothing, and instead it agreed to pay a full commercial rent. On the other hand, a very profitable scheme for Mr Conway and his family. They will make millions for Omet at the direct expense of the investors. All that said, I have to accept that the judge declined to find that Mr Conway was dishonest in what he did. His key finding in that regard, it appears in various places, but on page 93, paragraph 166, the judge finds that Mr Conway genuinely, and he found reasonably, concluded that something would have gone wrong at a general level, or he uses the words at a high level of generality in paragraph 167, if the annex were to pass to Southbank without charge. Now, he's there obviously not finding that he believed that there was any legal right to alter the existing contracts. And the judge is clear in paragraph 167 that Mr Conway didn't need to, in his view, look at it as though it was a possible claim for rectification. But what he seems to have found, although it's not entirely clear how he reconciles the rectification and the 2008 findings, is that despite the absence of any actual common intention in 2004, by 2008, Mr. Conway has come to the conclusion that this is not how he wanted the transaction to work. That's not how he wanted it to work. And we accept that on appeal, we cannot go behind that finding, that he was not dishonest. But as I will submit in due course in the context of Respondent's Notice, Ground 1A, that is absolutely no answer to the fact that Mr. Conway was plainly acting with a conflict of interests. And it is no answer to the fact that he ought to have been acting with single-minded loyalty in the best interests of South Bank as a separate company, and not simply looking at the general or high-level position across the group as he perceived it. And fundamentally, the problem with what Mr. Conway did, even on the judge's findings, is that he went into this looking to reverse something that he saw as unfair to him and his family, rather than doing what a director acting independently and in the best interests of South Bank alone would have done, which is to ask, should I give up the vested legal rights that I have? And we know that, in fact, given that rectification has been refused, the answer was there was absolutely no legal basis for it to give up those extremely valuable rights. For completeness and just finishing on the facts, I should say that the entire Annex Lease Scheme was put in place without informing, let alone consulting the investors. The judge finds on page 110, paragraph 240, that Mr. Conway accepted in cross-examination that he had concealed the Annex Lease Scheme, and he explains what he understands by that about halfway down the paragraph. Decision was taken because even though Mr. Conway, having received legal advice, regarded the scheme as proper and effective, he was concerned that if told, some investors might object. At the time he took that decision, Mr. Conway realised the investors would become shareholders of South Bank in 5 years' time, because that was an integral feature of the investment. Conscious decision not to tell the investors, to deprive them of any opportunity of objecting to what he was proposing to do. And of course, because of the 5-year delay, if I can call it that, in transferring control of the company, by the time the investors get control and discover what has happened, limitation very soon after passes, and Mr. Conway is therefore in the position he now is of being able to plead limitation to retain the benefits of his scheme. The judge finds, and we don't dispute this, that although that is concealment, it is not concealment from South Bank, i.e. the claimant, and therefore we can't rely on the concealment exception under the Limitation Act, because it would need to be concealed from South Bank, and at the time Mr. Conway represented South Bank and he couldn't conceal it from himself, and given that he was not acting dishonestly, we can't say that that knowledge is not to be attributed to South Bank. But the practical effect, of course, is it was concealed from anyone who had an interest, the real economic interest in doing anything of that. That's the reality. Outcome of all of this, South Bank loses the rights it had to enjoy the annex from completion under the FSC. Lodgeshine gets those benefits. Mr. Conway controls Lodgeshine. Mr. Conway and his family get the benefit in the form of rent. And those, we say, are the critical facts for my lords and my lady to consider. So let me then turn to the first group of grounds of appeal, which are related to the claims for breach of fiduciary duty about against Mr. Conway. Ground one is the limitation issue ground, And the sole issue which arises is whether the judge should have found that section 21(1)(b) of the Limitation Act applied to the claims against Mr Conway. And although I'm sure it's very familiar, given that I'm going to be making extensive reference to it, it's probably worth having section 21(1)(b) out. It's Authorities Bundle 1, tab 3, page 15. And section 21(1) effectively operates as an exception to any other limitation period by disapplying limitation for an action by a beneficiary under a trust in two circumstances. One is fraud or fraudulent breach. Of course, the judge's findings rule that out. And under B, where the action is one to recover from the trustee trust property or proceeds of the trust property, either in the possession of the trustee or previously received by the trustee and converted to his use. And I don't think it's controversial for me to say that the purpose of section 21(1)(b), amongst other things, is to stop a trustee or director relying on limitation where that would enable the wrongdoer to come away with or take the benefit of something which belonged to his or her trust or company. One thing for a trustee to say that they shouldn't indefinitely be exposed to having to make good loss and find themselves worse off. Another thing for a trustee or director to say that they should profit at the expense of the trust or company. So what I'm going to do is I'm going to start by approaching this in the way it appeared until a couple of days ago when my learned friends filed their supplemental skeleton, and then I'm going to deal with the point in the supplemental skeleton. So what was not an issue until then, and some of this is still not an issue, Mr Conway is to be regarded as a trustee for the purposes of section 21(1)(b) because he was a director. That is, as I understand it, still uncontroversial. And equally, the company is therefore to be regarded as a beneficiary under a trust, such that the opening words of section 21(1) apply. It was common ground, and as I say, we'll come back to this, that South Bank had an equitable or beneficial interest in the annex by virtue of the FSC. That point is now controversial, but I'm going to assume that is right for now and then come back to it. That beneficial interest, because it was something which belonged to South Bank, constitutes trust property within the meaning of section 21(1)(b). And further, it is trust property that is deemed to have been received by Mr Conway as trustee because he was throughout a fiduciary steward of South Bank's property. And we are told, now settled, that directors are deemed to be received the company's property. Also common ground, and is still common ground, that the word recover is not limited to proprietary claims. It can extend to a claim for equitable compensation in respect of the conversion of a company asset by a director. Now, if those...
And that's the Supreme Court case and Lord Briggs.
Yes. Now, if those elements are right, and as I say, some of those are now controversial, but if those things were right, the only two questions which would need to be decided were whether the property had been, the South Bank's interest in the annex had been converted to Mr Conway's use, and whether South Bank's action was one that sought to recover it, the interest. So these would be the only two elements that wouldn't otherwise be satisfied. And as I say, we do suggest that before you get into the detail of this, it is helpful to step back and just look at the practical reality, the substance of it, which is before the Annex Lease Scheme, South Bank has a beneficial interest, which will entitle it to the entire benefit of the annex from the completion date. And after the Annex Lease Scheme, it no longer has the right to enjoy the use of the annex. It only has a reversionary interest, and instead Lodgeshine, for the next 999 years, has the right to enjoy the entire benefit of the annex. And looked at in that way, which we say is the reality, the substance of the position, what has happened is that rights which belonged to South Bank are now in Lodgeshine. Lodgeshine controlled by Mr Conway. Mr Conway therefore has use of those rights. And that we will submit is precisely the situation section 21(1)(b) is designed to capture. Because otherwise, Mr Conway gets to keep the benefit of what it be assumed for these purposes is wrong in implementing the Annex Lease Scheme. Now, so far as we read it, the judge gave a single reason for disagreeing with that, and it's just helpful for me to show you that. It's at Core Bundle, tab 6, page 134. And it's really paragraphs 348 to 350. So paragraph 348 summarises the argument that my predecessor, Mr Bradley, King's Counsel, was making, and I should say, despite the complaints my learned friends make about how we put our case below, it's clear the judge understood it, and it's clear that we are running precisely the same case now. So he summarises the argument that South Bank held an equitable interest in the freehold, which constituted trust property, and 2, Mr Conway converted that to his use by granting to a lease to Lodgeshine, which enabled Mr Conway to derive an economic benefit. Judge says at 349, that's a stronger way of putting the argument, but he then sets out what Mr Trumpeter, King's Counsel, said in answer, which is that there can have been no conversion of the equitable interest to Mr Conway's use in circumstances where South Bank has since 2014 held that very freehold interest. I see the force of that argument. South Bank's complaint is not that it no longer has a freehold interest, but rather that the interest is being encumbered by the lease is less valuable, and he sees therefore real difficulty in treating that as recovery. And at the bottom of paragraph 350, having recited Mr Bradley's efforts to answer that point, he said that South Bank had not displaced Mr Trumpeter's analysis. So the gist of the judge's reasoning seems to be that provided the trust or company has property of the same legal nature before and after the breach, section 21(1)(b) can't be engaged. Doesn't matter if that interest has been encumbered or diminished in value. If you have a freehold before and a freehold after, they can't have been conversion, and you can't be trying to recover anything. With respect to the judge, we say that conclusion must be wrong. And I'm going to address that in four stages. First, I'm going to look at the legal nature of what granting a lease involves. Second, I'm going to look at the purpose of section 21(1)(b). Third, I'm going to look at the reasons why the judge's approach produces unacceptable outcomes inconsistent with existing authority. And fourth, I'm going to look at the language of section 21(1)(b) and identify why that doesn't support, let alone compel, the judge's conclusion. Taking first the effect of granting a lease. The difficulty with the judge's analysis, we suggest, is that the grant of a lease is not creating some entirely fresh proprietary interest out of the ether, leaving the freehold untouched and as it was before. The reality is that the lease is being granted out of the freehold. It is carving out part of the rights and interests which had previously vested in the freehold, the right to possession of the property, and it is transferring those, taking those as part of the bundle of rights and putting it into a different interest. And that's why we can then talk about a freehold reversion, because the freehold has changed its nature. It is not simply all the rights it was before. It is now only a bundle of rights which includes the right to enjoy the property upon the end of the leasehold.
And the freehold is encumbered.
Either, my lady, you could say it's encumbered. Certainly it's encumbered. I would go further than that and say
It's hollowed out.
it's hollowed out. If you think of it as a physical piece of property, someone has come and cut part of it and physically lifted it out and written leasehold on it. So what you now have is a freehold with a giant hole in the middle. That's the reversion, the bits that's left.
A husk.
A husk. And that's, of course, why one talks in the Land Registration Act, for instance, regards the grant of a lease as a disposition of the freehold. It is not the creation of an entirely new estate that doesn't touch upon the freehold. It is a disposition of the freehold itself. Only part of it, but it is a disposition of the freehold. And so we say that the judge was simply wrong to proceed on the basis, as he seems to have done, that they held the very same interest, the very freehold interest, as he puts it, both before and after the breach, such that nothing had been converted and nothing could be recovered. That, we say, simply ignores the fact that the leasehold is not the very same thing it was before. It has substantially changed its legal nature, and part of the bundle of rights that it represented have been taken out of it and put elsewhere.
Can I just ask this question? Suppose that you just have a trustee, really simple case,
Yes.
trustee of a freehold. The trustee just grants himself a lease.
Yes.
Is the judge saying that the beneficiary keeps the freehold in that case? That seems to be what he's saying.
It is.
And then, therefore, for the purposes, sorry, I know this is leaping ahead a bit, but for the purposes of section 21, the beneficiary would still have the property,
Yes.
and there wouldn't therefore be any, on the judge's reasoning, it would seem, there wouldn't be any
Action to recover.
action to recover.
Yes.
using the words.
You probably wouldn't need conversion in your simple example because it would be in the possession of the trustee. But you wouldn't have an action to recover at all because on the judge's reasoning, well, the trust still has the freehold.
But one thing I haven't worked out in relation to all this is, take that sort of example. Would there actually be a true trust of the lease? Such that you wouldn't be in section 21 territory at all?
So if it was a simple trust for sale, trustee holds the freehold on trust for sale for a beneficiary, yes, you'd have a straightforward, in my submission, a straightforward trust of the freehold. And if that will, in my Lord's example, simply leased to the trustee, assume not dishonestly, but that wasn't discovered for 7 years, you would, and the beneficiary came and said, well, I would like that lease back. I'd like that lease to be damages, let's say, because you have diminished the value of my property. Yes, it would seem the beneficiary in that scenario would have no claim because it would have to be brought within the recovery of trust property situation. Otherwise, it's a straightforward breach and the 6 years applies. And the judge would say, well, it's not to recover anything because the freehold, the trustee still holds the freehold.
And I sort of see all that. One thing that's sort of confusing me as I try to think about any of these things is the Supreme Court in FHR and subsequent cases has affirmed the idea that you get a true trust where there might not previously have been thought to be a true trust.
Yes.
And if there is a true trust, I'm not sure that these arguments bite in quite the same way. I mean, that's not to the beneficiary's disadvantage, but I think the nature of the legal arguments changes a bit.
Well, in my submission, I don't think it does affect, or I'd submit it doesn't affect
It
the
may
way the
not affect
judge
what the point you're
approached it.
making, no.
Well, or the way the judge approached it. But I
No.
don't think at this point the judge isn't, partly because it was argued below on the matters which were common ground until my learned friend's supplemental skeleton. On the judge's view, it doesn't matter what the nature of that trust is. It could be a bare declaration of trust. It could be the sui generis sort of trust that arises under a specifically enforceable contract for sale. His reasoning is simply, you have the freehold before, you still have the freehold after, that's the end of the matter. And that, whatever the nature of the trust, well, it isn't affected by the nature of the trust. I can see that different issues may arise, and my learned friend certainly says, well, this isn't the right sort of trust, or is maybe not a trust at all, and therefore you shouldn't really be engaging Section 21. But the judge's reasoning comes in at a higher level and must, in my submission, be...
And I see that, at the risk of confusing everybody. Suppose you have a cow.
Yes.
Suppose a trustee has a cow.
Yes.
And suppose a company has a cow and the director takes all the milk from the cow for
Yes.
however many years. Well, the company still has the cow,
Yes.
but the fruits have gone.
Yes.
So what happens then?
Well, my lord, I hate to give you an answer which probably depends on the fact. Of course, the milk itself would, as soon as it's produced, be owned by the company, and so you would still just have an outright conversion there of the milk. I mean, later on, I was going to give an example of, well, what would happen here if there'd been a fixture on the land, and the director had agreed to sell himself the fixture. So say there's a machine bolted into the ground. Director agrees to sell himself the machine and removes the machine from the freehold and takes it away for his own use. Now, the reason that's sort of like your cow example, but different, is that, of course, so long as it's a fixture, there is no independent property in it. And in my scenario, it goes straight from being a fixture on the ground as part of the freehold to being property of the director. Now, on the judge's reasoning, he would say, nothing to recover. Company had the freehold before, company has the freehold after. The fact that something's been removed from the freehold and reduced the freehold in value is neither here nor there. And I just paused to say, I can't put it any more legally nicely than this. How can that be right? If the director has taken something which formed part of the freehold for his own benefit and devalued the property that the company has afterwards, how can that not be a scenario to which Section 21(1)(b) applies? The judge's reasoning, full freehold interest after, full freehold interest before, nothing converted, nothing to recover, bad luck. It can't be right.
But what you would also say, Anne, is that freehold before, freehold reversion afterwards, therefore different.
Yes. But ultimately, I say this really ought to be a point of substance, and whether it's removing a physical object or removing part of the bundle of rights doesn't make any difference. Property is ultimately a bundle of rights. If you take some of those rights out of it and give them to someone else, you have changed the property interests. And nice analysis of whether that is the same freehold isn't the right way of looking at it. And that really flows into my second overarching point about purpose. Because ultimately, this section has to be construed by reference to its purpose. And if I could take my lords, my lady, to Burnden Holdings, that's Authorities Bundle 4. tab 45. I'm not sure if I'm allowed to say this, but pleasingly short judgments.
Certainly, some of the others are much longer.
They are.
Exactly what I thought was brilliant.
Well-known case, and I know my lady Justice Asplin has already referred to it. Issue in the case was whether Section 21(1)(b) could apply where the trustee never personally received the company property, but it simply flowed through another series of companies in which the directors had majority shareholding interests. And you see that page 1241. Three lines down from the top. Rather, Mr Chivers' focus has been on the remaining part of Section 21(1)(b) by way of the submissions that the relevant trust property was never in the possession of the defendants or previously received by them and converted to their use. The gist of his submission was that from the start to the finish, shareholding has been in the legal and beneficial ownership and therefore possession of corporate entities. And the argument therefore was, well, it was never converted to the director's own use because it was only ever held by the companies. And Lord Justice David Richards, as he then was, in paragraph 14, in the Court of Appeal, David Richards LJ acknowledged that this submission responded well to a literal reading of Section 21(1)(b). So, of course, might say it's trite company law that if a company holds property, unless you can pierce the veil, it is the company's property, and so one can see the attraction of Mr Chivers' argument, well, it can't be in the use of the director because it's in the use of the company. Supreme Court, for reasons that differ from the Court of Appeal approached it as an anti-avoidance issue. Supreme Court said that wasn't necessary. They deal with it as a matter of purpose. So going over to page 1242, paragraph 17, the starting point in the construction of Section 21(1)(b) is to pay regard to its purpose. That was laid down in Re Timis by Kekowicz, Justice Kekowicz. The intention of the statute was to give the trustee the benefit of the lapse of time when, although he had done something legally or technically wrong, he had done nothing morally wrong or dishonest, but it was not intended to protect him, where if he pleaded the statute, he would come off with something he ought not to have, i.e. money of the trust received by him and converted to his own use. And it said that has been confirmed to be the purpose of Section 21, the current Act, in the Harrison case. And so the dividing line is clear. If you're not a dishonest trustee, you get the benefit of limitation. But that is not to be the case if you would take a benefit, you come off with something that you ought not to have had. And the logic of that, if I may say, is obvious. One thing to say that a trustee should not be indefinitely exposed to liability and at the risk of being made worse off for having done something, for instance, negligent, lack of care in the investment of the trust's assets. But it's quite another to say that the law should allow a fiduciary to retain the benefit of something which the trust ought to have had and he has converted to his benefit. And applying that purposive approach in paragraph 22, page 1243, the Supreme Court gave short shrift to the suggestion that Section 21 didn't apply. They say on the assumed facts that there was a conversion when they procured or participated in the unlawful distribution. It was a conversion because it was the taking of the company's property in defiance of the company's rights of ownership of it. And it was a conversion to their own use because of the economic benefit which they stood to derive by virtue of being majority shareholders. So reading paragraphs 17 and 22 together, the way the Supreme Court approaches, well, let's think about the purpose of the section. Purpose is to stop a trustee getting the benefit of something that the trust ought to have had. That is exactly what's happened here, because something has been taken from the company in defiance of its rights of ownership, and now the trustee is able to benefit from it. And that cuts through any technical or formalistic reasoning about, well, it never was actually in the hands of the trustee themselves. And we say this case is particularly important because it tells this court how Section 21 is to be interpreted, which is by reference to its purpose and by reference to the objective of stopping trustees or directors taking things or having the benefit of things, having the use of things which their trust or company ought to have. And just doing the paragraph 22 analysis here and applying the purpose, there can be no doubt which side of the line this case falls. If we are right that Mr. Conway procured the Annex Lease Scheme, designed and implemented the Annex Lease Scheme in breach of his fiduciary duties, then this is a case where he has come off with something which South Bank should have had. That is the beneficial interest, the right to use and enjoy the annex. And allowing him, as the judge has found, to plead limitation means that he and his family are entitled to take the benefit of that wrong for the past, because part of this action was to cover arrears of rent. And indeed, the conclusion is that they will be entitled to continue to do that for the next 970 odd years, either by insisting on a lease or by demanding mean profits, or perhaps by ousting South Bank from possession at all if the lease comes to an end. And that, we say, is precisely what Section 21 is designed to avoid. A trustee or someone in the position of a trustee reaping the benefits of their wrong at the expense of their own trust. And for all of my learned friends, as one would expect, well-developed technical arguments, his skeleton is strikingly silent on how the judge's conclusion can possibly begin to be reconciled with the purpose of Section 21. There is, I don't think I need to turn it up, there is a bold assertion that our arguments on purpose are, quotes, overstated, but no explanation of why. And no doubt my learned friend will address you, but I would invite you to infer the reason is that there isn't a way that the judge's conclusion could be reconciled with the purpose of Section 21. Now, it may be that this is some lacuna in Section 21 that your lordships, your ladyship are simply forced to construe Section 21 in this way. But that is something you should only do if you are absolutely driven to it. And as I'll submit, there's absolutely no reason why you are driven to it. And the judge, we submit, perhaps due to his failure to refer to the purpose and consider it fully, misconstrued Section 21(1)(b) and failed to look at the substance of the position, became overly concerned about the technical form of the interests. My third point is that, and it's really linked to purpose, is that if the judge's approach were to apply more generally, it produces very odd outcomes that can't possibly be what Section 21 is designed to achieve. Before I get to some of the sort of analogies, it is an oddity that if the Annex Lease Scheme had been achieved through the grant of a freehold interest in the annex, which was in fact contemplated at one stage, but there were issues about flying freeholds, and for some reason it wasn't done in that way. Presumably, the judge wouldn't have had any difficulty applying Section 21, because then Southbank wouldn't have had the same property before and after. It would have had a freehold over different physical property to what it had before. But why? Let me put it the other way around. But the effect of granting a 999-year peppercorn lease is, for all intents and purposes, the same as disposing of the freehold. I appreciate that's an oversimplification, but in practical terms, a 999-year peppercorn lease is granting the entire benefit of the property. Why should it make any difference that one is done by a transfer of the freehold, one is done by the grant of a leasehold? Why would Section 21 distinguish between those two scenarios? And if one can't answer that question, it suggests that Section 21 doesn't draw this distinction. But more generally, there are many situations, we say, where it can be said, as the judge did, that the company holds property of the same legal nature before and after the breach, but the trustee has nonetheless come off with something that belonged to the trust, such that Section 21(1)(b) ought to apply. And the example which I would suggest is most powerful is a transfer of money out of a company's bank account. Now, as a matter of law, the company has a shows in action against the bank by virtue of its account opening contract, or whatever it be, to demand from the bank whatever balance stands to its account on the given day. Now, if money is transferred out of the company's bank account, it still has precisely the same shows in action. It has its contractual right to demand what stands to its account in the bank.
Is that really right?
Well,
I mean, you have a right to demand a different amount of money.
well, my lord, the answer is it's not right, and that's why the judge is wrong.
But you say, well, the company's right would be the same. So the judge's approach would apply by analogy. But would the company's right be the same? Expressed in terms of you have a right to demand whatever is standing to your credit, it's the same right.
Yes.
But it's a right to a different sum of money.
It is, in precisely the same way that the judge erred in saying that there was the very same freehold. Because, yes, it can be said at a legal abstract nature, it is the same freehold. It's called a freehold title, reference TL, ... But it is a right to a different thing. It is a right to enjoy the reversion after a certain period of time. So in a sense, I'm not really advocating that this would be the right analysis. What I'm saying is, if you take the judge's analysis, that you simply look at the legal right at a very high level of abstraction and don't look at what it actually entitles you to enjoy, the substance of the legal right, it leads you into error. And so either the answer must be the situation is the same with the company bank account and the freehold. It's not the very same property. It is a diminished piece of property because although your formal shows in action is the same, it actually entitles you to substantively less. Or if the judge's reasoning would apply equally to the company bank account situation and can't be right. And in many ways, that's, if I may say so, it's demonstrated by my learned friend's skeleton. I don't know if your lordships have that separately, my lordship's ladyship have that separately, or if you have it in the bundle.
I mean, most people would say if the company has £1 million in its bank account on day one and £500,000 on day two, it's got different property. It's got £1 million in the first place and £500,000 in the second.
My lord,
It's a super legalistic way of saying, well, they're both shows in action.
it is. I accept that. And in many ways, that is, I fear that what I've done is provoke your lordships into making the argument that I'm actually trying to make by demonstrating the artifice
You
of
say
the
the judge was
counter-analysis.
super legalistic.
I do. Because equally, if you ask, if you were to ask any sane person on the Clapham Omnibus, or whatever the equivalent now is, the Northern Line, does Southbank have the same property before and after the Annex Lease Scheme, they'd say, you're mad, of course it doesn't. Before it had the annex, it could, from the completion date, it had absolute entitlement. It could go into it, could turf anyone else out, didn't have to pay a penny for it. After the Annex Lease Scheme, it's got a precarious temporary right to use it if it pays market rent. And in any sane world, that's not the same property right.
What you're saying is, in the same way as the judge said, the freehold was the same. You're saying you could say legalistically that a right to the shows in action in relation to the bank are the same, but that's just saying that the wrapper is the same, but we're back with the husk.
Exactly so. I mean, my lady has put it better than I could, and certainly I have. It's the problem that the judge is looking at it as, how do you describe the wrapper? And that's really the only point I'm making, that if you were to apply this same approach to a bank account, you would say, at a very formalistic legal level, it is the same legal right, because it's not a right to demand £10. Strictly speaking, your legal right against a bank is to demand the balance of your account. And that legal right doesn't change day to day. You have the same contract the day you sign up to the bank as 10 years later, but its value changes, its substance changes, what it practically entitles you to changes. Same to the freehold. And I was just going to take my learned friend's skeleton at paragraph 26.2. Where he says, my analogy with a shows in action is inapt. A shows in action is a personal right of property. Well, of course, that's true. In the hypothetical example of the bank transfers, the shows in action are not the same after the transfers in question. They are different, decreased, increased in value. Well, absolutely. But ditto the freehold. It is very significantly decreased in value as a right to occupy the property for the next 999 years free of charge, and a mere reversion after 999 years. No one would describe the absolute owner of a house, the full freeholder, as having the same sort of property interest as the freeholder of a block of flats that holds where all the flats are on long leaseholds. They are fundamentally different property interests with different rights and benefits attached to them. And that is the reality of what has happened here. The property has changed by being diminished not simply in value, but in legal content. What can you actually do by virtue of having that right? Also, I gave the example of of a fixture to the land being removed, sold and removed. Again, judge's approach, technically freehold before, freehold after. But again, that can't be right. There must be an ability to bring a claim to recover that fixture from the trustee. We'd equally say that imagine a scenario where a director causes his company to grant a legal charge over property for the purpose of securing a loan to himself from a bank. As a result, the company can't dispose of that property, it can't sell it when it wants to sell it, and it suffers a loss. We would say that is an obvious situation for section 21(1)(b) to apply, because the director has converted the company's property, acted in a way that defies the company's rights, for his own use, to raise funds for his own personal benefit. But my learned friends say that the grant of the charge, at least unless it involved a transfer of a legal, the freehold subject to an equity to redeem, wouldn't be a conversion to own use. Again, we say that must be wrong. That must be the sort of scenario where section 21(1)(b) can apply. And we say that was certainly the way it was approached in the Haysport case. And I just show you Lordship, Your Ladyship, that I accept it didn't deal with this point in any great detail, but Authorities Bundle 3, tab 40, page 995, paragraph 14, NLPH is a company of which the director, Mr Ackerman,
I'm sorry, Mr.
Sorry.
Could you give me the page again?
995,
Thank you.
paragraph 14 at the bottom of
Thank
the
you.
page. NLPH, company New Liberty Property Holdings, is a company which was held through a discretionary trust, of which Mr Ackerman, who was the defendant, was a beneficiary, and he was also found to be the driving force behind what NLPH did in this case. So not formally a director, not formally a shareholder, but a discretionary beneficiary and the driving force behind it. It obtains a loan from Lloyds TSB for 10 million, and the claimant companies provided security in respect of those amounts. Also, one of the claimant companies itself granted a direct loan note, but leave that to one side. That's not of interest for what I'm concerned with taking from it. If you go, please, to page 1009. Paragraph 104, judge has already made a finding that there was a breach of fiduciary duty, and then comes to deal.
And just so I understand, what was the breach of fiduciary duty?
It was that he was a director of or I think a shadow director of the company which granted security. The claimant granted security and granted the loan note. And at paragraph 102, it's found that he failed properly to consider the interests of the claimants and was therefore in breach of his fiduciary duty. So effectively, the allegation was that he had granted this security when it gave no real benefit to the claimant companies and in circumstances where there was significant risk that it would be called upon.
So he had caused the company to grant the security in breach of duties which he owed as a director or shadow director.
Or shadow director, yes.
Yeah.
And he stood to get benefit from that because he was a discretionary beneficiary of the company which obtained the 10 million loan. And you can see that paragraph 104 that the judge refers to both types of breach of duty, former relating to the giving of security, the latter in relation to the loan note. He finds all of those breaches are made out. Paragraph 105, he says limitation has been pleaded. And then he explains the exceptions being relied on at 105.3. They contend that the advancing of the monies to NLPH, that's the loan note, and the giving of the securities was done to confer a benefit on a company controlled by Mr Ackerman and therefore falls within section 21(1)(b, following re Pantone. In that case, no period of limitation. And at paragraph 106, the judge finds that following that case, they involved handing over property to a company in which Mr Ackerman was interested. Those operations were in breach of his duties. Accordingly, they are liable, even absent the finding of dishonesty. And I accept, as I say, that the judge did not consider in any great detail how section 21(1)(b) operated, but he plainly concluded that even the granting of security...
Before you put it away,
yes,
just to get some clear, for what was Mr Ackerman liable in respect to the grant of security?
in the end, I think, and I will check this, the loan defaulted and the claim was to recover the amounts arising. But let me check that and I will confirm that after lunch.
So on that thesis, it would be that there was a claim on the security that the company
Yes,
had given.
I think so. Let me check that. I don't want to
Yeah.
I'll check that and I'll confirm it. But what I take from it, as I say, I accept it wasn't reasoned in this point wasn't reasoned in great detail. But the judge plainly thought that section 21(1)(b) could apply simply by virtue of the giving of security over property. And we would say that must be right. Why, if a director uses their company's property by encumbering it in order to make a profit for themselves, why should that not be caught by section 21(1)(b), having regard to the purpose of that section, which is to stop the director coming away with a benefit from their conversion, their defiance of the company's interest in the property, and instead using that property for themselves? But again, we could still say, well, the company still has a freehold before and after, but nonetheless, that's no answer to the point, because the property has still been used, converted to the use of the director. So we submit, and I'm sorry if I've sort of put it back to front by trying to make the analogies and saying, look at what the judge's conclusion would do, but it's really to make the point my Lady Justice Asplin made, which is the judge's approach of looking at it at such a high formalistic legal abstraction conceals the true nature of what has happened and defeats the purpose of the section, because it doesn't look to the reality of the fact that even if you have what can strictly be described as the same property or shows in action, it can be very significantly changed in its value, content, and nature. And a freehold subject to a 999-year lease is a very different piece of property from an unencumbered freehold, just as a bank account with £10 million in it is a very different thing to a bank account with £1 million in it. Fourth and final point is that we say there is nothing in the language of section 21(1)(b) which leads to the conclusion which the judge reached. He seems to have concluded that Southbank couldn't recover anything because it had the freehold. So if it had the freehold, it couldn't be recovering the freehold. But the difficulty with that is recovery has never been, or certainly is not understood as being limited to getting back a proprietary interest which has been lost. That's obviously a point covered in Burnden, although it wasn't controversial there, that one can have recovery in the form of damages, equitable compensation for the conversion of property. And so there is no reason in our submission why recovery cannot involve or cannot cover an action where the claimant is saying the bundle of rights which I had has been diminished and I want money that will restore that property to what it would have been but for the conversion of some of those rights. It's effectively trying to put the property back in monetary form to the substance it was in before the conversion. And I would just point out, although I don't need to go this far, that in re Axminster Carpets, and that's, I'll turn it up if you've seen the passage, it's Authorities Bundle 4, tab 51, page 1525. It was the case is an extremely complicated, at least for me, pensions case, where there was a subsidiary issue as to whether the existing pension beneficiaries would be able to sue the trust for underpaid arrears of pension. So I think there's been a miscalculation as to how the pension had been paid, and the question was, would the beneficiaries have a right to recover those arrears, even if they were more than 6 years old? And so the question that was being asked was, would section 21(1)(b) apply to a claim by a pension beneficiary to be paid arrears of pension from the pension trust? And at paragraph, sorry, it's page 1535.
So 1535.
Sorry, let me slow down. 1525 at paragraph 110. You see what I've hopefully just described. The specific issue is whether an action brought by a beneficiary against the trustee for arrears of pension at a time when the trustee is in possession of trust property would be an action within section 21(1)(b). And then on page 1535, paragraph 156, 3 lines down, it said the only argument raised by Mr Legg as to why such a claim was not within section 21(1)(b) was that the provision required the beneficiary to show that it had a pre-existing proprietary interest in the subject matter of the claim. I'm not able to find any words in section 21(1)(b) which impose that restriction on its operation, no authority which supports the suggested restriction. I also find that such a restriction would be contrary to the purpose of section 21(1)(b), and he therefore concludes the provision is not to be construed in that way. Now, the only reason I draw attention to this is if section 21(1)(b) can apply where the beneficiary never had a proprietary interest in the trust property before or after the breach of duty, why should it make any difference if the beneficiary, i.e. the company in our case, has the same proprietary interest before and after the breach?
Sorry, can you just say that again so I get it down?
If it's section 21(1)(b) can apply where the beneficiary has never had any proprietary interest in the trust property, either before or after the breach, why should it make any difference if the beneficiary, so the company in our case, has the same proprietary interest before and after the breach? Put another way round, the concept of recovery does not require that the beneficiary had a proprietary interest which it has lost. May never have had a proprietary interest at all.
So just to understand what Mr Justice Morgan was dealing with, so the claim to recover arrears
Yes.
fell within section
1(b).
because
So he reads recover very broadly and says that it's no reason why it can't simply apply to a claim to get the benefits you're entitled to, an account of the benefits you're entitled to out of the trust,
yes, I see.
even though the beneficiary never had any proprietary interest in any particular trust asset. As a beneficiary under a pension trust, he simply had a right to be have distributions to him in accordance with the pension scheme. And so, certainly on Mr Justice Morgan's reading, the concept of recovery does not require that the beneficiary, the company in our case, has a proprietary interest which has been lost. And therefore the judge's apparent assumption that you couldn't have an action for recovery because the company had the freehold before and after simply doesn't follow. No reason you can't have a conversion to the director's own use because the director gets some benefit from it, and that recovery can simply be damages to reflect the harm done by that conversion.
I'm not quite sure I follow the relevance of it, sorry. Because here the company, on the assumed basis that you're arguing this,
Yes.
did have an interest.
It did.
And so this is a sort of, it's an interesting sideline, as it were, but I don't see how it helps us either way on the point we're dealing with.
The reason I suggest it is helpful, that I accept at the margins, is if the judge were right that you can't have an action for recovery unless you have lost some property interest, because you can only recover if you don't have the same property after the breach as you had before, then Mr Justice Morgan must be wrong, because that certainly wouldn't apply in his scenario. And so I accept it's different because the company does have a proprietary interest in our case. But it, in my submission, suggests that the judge's reading of recover is much too narrow because it would exclude this sort of scenario where there was never a proprietary interest, because in that situation the company can't have lost a proprietary interest which it's then seeking to recover. And why should the claimant be worse off in situations where it did have a proprietary interest but it's not lost it than if it never had a proprietary interest at all? And I don't put it any higher than saying it does demonstrate, in my submission, that the judge was just thinking about recovery in a much too narrow manner. That he is thinking of, you can only recover if someone stuck their hand in your pocket, taken something out of it, and you want, in damages or otherwise, that thing back. And that is just not what this section is limited to.
And just relating for a moment your case to the wording of section 21(1)(b.
Yes.
On your case, as I understand it, your claim against Mr. Conway
Yes.
is to recover compensation
Yes.
from Mr. Conway
Yes.
in respect of property of South Bank,
Yes.
which was converted to Mr. Conway's use.
Yes. Being the beneficial interest in the annex, which was converted to his use by him procuring that it is brought into Lodgeshine, where he has control of it, and he can direct the benefit into his own pocket and his family's pocket. And that is an action for recovery, because recovery can include damages for that act of conversion, i.e. to restore the value of the rights. We need damages to restore the value of the rights. In other words, to pay for what we now have to pay to enjoy the rights we would otherwise have had to occupy the equally, the judge seems to have been troubled by the concept of conversion to the trustee's own use. He seems to have thought, well, you can't have converted the freehold if you still have the freehold. Again, we suggest that is simply too narrow a reading of what conversion is. Now, there is not any great exposition, by which I mean, as far as I can tell, any exposition of what conversion means in this context. It's obviously not conversion in the tortious sense, because you can't have conversion of intangible rights at tort, but you obviously can have conversion of intangible rights for the purposes of section 21(1)(b). But we submit that the essence of conversion is what the court saw in Burnden, which is ultimately simply a defiance of the company's rights of ownership of the property. True in that case, that was by virtue of a taking, because it was a distribution, but there's no reason why it should be limited to takings. It is anything which defies the trust's rights of ownership of the property, and instead results in the director using those rights for his own benefit. And that is simply a matter of natural language, a conversion of the rights to the director's own use. Company has rights, now the director controls them, has converted them, changed them so that he can use them personally, and it's consistent with the purpose of section 21(1)(b), which is about stopping directors retaining, benefiting from the use of company assets. And that use can come, we submit, in any form: an encumbrance, a transfer, even, we would suggest, the physical act of possession. If a director simply took a machine that belonged to the company, used it for many years to make money, and then returned it, we would say that is still, even though there's been no transfer of title at all, there has still been a conversion of that piece of property to the director's use. And the director could therefore be sued for mean profits for having done so.
Seems to connote some sort of legal wrong, doesn't it? Would you accept that?
I would, and certainly in Burnden, it was said it was a conversion because, assuming that it was a breach of duty. So yes, I accept that, although in a sense that's going to be inevitable because you otherwise wouldn't have a breach. But yes, I accept conversion. The director doesn't convert to own use simply by using it in a proper way. The essence, and I'd submit you have to read that phrase converting to own use as a whole. The essence of it is saying the company ought to be enjoying this, but now the director's using it has brought about a situation where it's now benefiting him rather than the company. And that fits with the purpose, because the purpose is stopping directors, trustees, coming away with the benefit of trust property. So in our submission...
I'm sorry, does there have to be a breach of duty by the director, by the trustee?
Well, yes, I think I would accept yes. It couldn't simply be a moral wrong, but in a sense it's not going to get you anywhere if there was no breach, because you'll get through limitation but then you'll fail on breach.
It has to be an action by a beneficiary.
Quite. So it'd be a Pyrrhic victory to say that you could get through limitation without a legal wrong, but then fail for an absence of a legal wrong.
Yeah, I only ask that because Mr Justice Kekovich seems to have contemplated something called a moral wrong, I think, but
yes,
that seems improbable.
I think that's right. And I think he was, in a sense, using that in a different context, which is he was saying you might actually fail on limitation if there was a legal wrong which was either dishonest or morally wrong. And he was envisaging that as a separate exception. Now, whether that's right or wrong is a different question, but I think that's the context in which he was using it to distinguish it from technical wrongs, but which result in a profit to the director. So for all those reasons, we say, straightforward case here, really. South Bank has the beneficial interest before, doesn't have it after. Instead, Mr Conway has use of it, and that is why section 21(1)(b) applies. That's a convenient moment to then deal with my learned friend's new argument, and that is in his supplemental skeleton argument. I think you have, I hope you have, a respondent's supplemental skeleton bundle, and his skeleton is at paragraph, 3 of that.
Not aware of having a supplemental skeleton bundle.
I just have a short skeleton.
I see some copies are about to be handed up. There's a skeleton and a couple of authorities, so it's probably worth you having it.
I also have the separate authorities.
Well, then you have everything.
I don't think I'm so lucky, so I'm looking forward to receiving the bundle.
Thank you.
And if I can be, so it's in his skeleton, which is tab 3, bundle page 10, paragraph 4. And I hope you'll forgive me for skipping to the punchline. But what my learned friend seems to be saying is that I am wrong to talk about South Bank having a beneficial interest in the freehold. And as you see at the bottom of the page, he says that actually what South Bank had, the relevant trust property, was South Bank's right in equity to seek specific performance, and that granting the lease didn't convert the right to seek specific performance, nor was it proceeds of that right, and nor are we seeking to recover that right. In fact, Mr. Conway never interfered with the right, i.e. to seek specific performance at all. And what I think is trying to be done here is to address my idea of the freehold as having something carved out of it, and say actually we never had a beneficial interest in the freehold, we merely had a right to seek specific performance, we still had a right to seek specific performance, and therefore all my interesting points about carving out don't work. Two answers to it. First, he's wrong about the nature of the interest, and second, it wouldn't affect my analysis even if he were right. So taking the first of those points, the argument that all South Bank had was a right to seek specific performance is too limited. It is because there is a right to seek specific performance that an equitable or beneficial interest in the land arises. The true principle is that the vendor is a trustee, albeit of a particularly an unusual kind, and that the purchaser does acquire a beneficial interest of a proprietary nature, albeit again one of an unusual nature because it is subject to the terms of the sale and the vendor has their own interests in the trust property, i.e. to be paid and indeed to continue to benefit from the property until the completion date. Can I, if I may, just hand up a couple of authorities that we have come up with, if I can put it, this week in light of the supplemental skeleton. And I do this because it actually brings together things in quite a convenient way. So Snell is at tab 2. Paragraph 24002 deals with the nature of, as you see from the heading, trust giving effect to a specifically enforceable obligations. And what the editors say is, when a specifically enforceable contract for sale has been made, the effect in equity is to divide the beneficial interest in the land between the vendor and the purchaser. The vendor retains the legal estate, but does so as trustee for the purchaser. That is on the provisional assumption that specific performance is available and it will in due course be completed. The incidents of the trust are determined by the parties' contractual rights, since the trust only gives effect to the transaction contemplated in the contract. And just pausing there, it's not unusual to have trusts that do give effect to contractual arrangements. One can think of notes and so on where that is perfectly usual. But the important point I take from that is that A, the vendor is a trustee, and B, there is a division of the beneficial interest. It's not simply a mere right to seek specific performance, it is a trust relationship with a division of beneficial interest. Going on, it's explained that this has two functions. First, as against the vendor, it imposes certain duties pending completion, even though they are not specified in the contract. In particular, those are to protect the property to be conveyed. And as I will show the court later, interestingly, one of those duties is not to relet the property because it will change the legal nature of the thing which is to be conveyed. The second purpose is its effect as against a third party to the contract by treating the purchaser's contractual right as an equitable interest in the legal estate. The priority of the purchaser's right to a conveyance is preserved against the third party. Now, of course, that it applies to land. It also applies in other specific enforceable contracts, shares in private companies being the classic example. But given that this is an interest which can be asserted against a subsequent purchaser, it is necessarily a proprietary interest in the thing, not merely a personal right to seek specific performance against the original seller. It is something which, a right which travels with the property. I use that because Snell obviously is an authoritative summary of what the law of equity is in many respects, but it's also helpful, and I've done this by reference to tab 1, Englewood Properties, Mr Justice Lawrence Collins, as he then was, to see how this has been established in the authorities. And if I could just ask you to go to page 12, rather than put in the raft of authorities which establish this proposition, Mr Justice Lawrence Collins did so in the Englewood case.
Sorry, where are we?
Tab 1, page 12, paragraph 40.
Yeah. Yes.
So the heading is the vendor as trustee. Long been said that after contract until completion, the vendor becomes in equity a trustee for the purchaser. Some of the more characteristic statements in the period in which the principal is settled include these. It starts with Lysact and Edwards, Master of the Rolls, Sir George Jessel. And you see in the middle of that, well, firstly he says that the effect has been settled for more than 2 centuries. And then he asks, what is the doctrine? And in the middle of that quote, he says, it is the moment you have a valid contract for sale, the vendor becomes in equity a trustee for the purchaser, and the beneficial ownership passes to the purchaser, the vendor having a right to the purchase money, a charge or lien on the estate for the security of that purchase money, and a right to retain possession of the estate until the purchase money is paid. And that reflects this idea of dividing the beneficial interest. Because, of course, the vendor does still have the right to benefit from the property until completion. And at the bottom of the page, you see Sir George Jessel said that it was in the form of a constructive trustee relationship. Over the page, Sir George Jessel again in Earl of Egmont. He is certainly a trustee for the purchaser, a trustee no doubt with particular peculiar duties and liabilities. Fallacy to suppose that every trustee has the same duties and liabilities, but he is a trustee. And then there is reference to Shaw and Foster, House of Lords. Shaw and Foster is the next case down. George Jessel appearing there as Solicitor General. And you can see the House of Lords said, can't be the slightest doubt of the relation between vendor and purchaser. The vendor was the trustee of the property for the purchaser. The purchaser was the real beneficial owner in the eye of the Court of Equity, subject to this observation. And again, the court goes on to make the point that the seller continues to have an interest pending completion. Then Clark and Rammers, I don't need to refer to that. And then at paragraph 41, there are some more recent cases. Berkeley and Poulet at 41A, duties and rights arise from the contract of sale. The vendor is said to be a constructive trustee or a trustee sub modo of the estate for the purchaser from the time when the contract is constituted. And then over the page, Heronsgate Enterprises, Vice-Chancellor, says well-established law that subject always to the terms of the contract, a seller of property under a specifically enforceable contract is to be regarded after the contract as holding the property as trustee for the buyer, but he is not a bare trustee. And so, and indeed, just going, there's then a reference in paragraph 42 to the various ways that relationship has been described, all of them by reference to trusteeship. And then over the page on page 15, Mr Justice Lawrence Collins refers to the Law Commission report where he quotes paragraph 2.8, and you see between D and E, the Law Commission considered whether to abolish the trust concept, and they concluded that the trust should remain undisturbed. So something, in fact, considered as for reform, but decided to leave how it was. Now, there is can't, I suggest, be any sensible suggestion that that well-established law, including a House of Lords decision back in 1872 of Shaw and Foster, that a beneficial interest does pass under a trust, have been overturned.
You're leaving this just before you do.
Yes.
Picking up a point you were making a moment ago, if you go to the quotation from Heronsgate
Yes.
in 1B,
Yes.
you see Sir Donald Nichols saying the seller must take care not to damage the property or to prejudice the buyer's interest in the property. It's a very general statement. Is that something that you endorse?
It is, and indeed, if you go on, if I can just
Yes.
go on to paragraph 54, and dealing again with this point, now Mr Justice Lawrence Collins, he's dealing with why you have this trust, and he's talking about the duty to preserve the property. And if I could just ask you to look at E. So also the vendor should not re-let the premises without consulting the purchaser, since to do so would present the purchaser on completion with property in a legal state different from that which he contracted to buy. And I don't know if that was, in a sense, where my lord was going with the point, but this is exactly it. The trust is there to preserve the thing that the purchaser is going to get, in this case, the full beneficial interest to the annex from the date of completion. And that is precisely what Mr Conway stripped out of it by not re-letting it, but letting it for the first time on these extraordinary terms. Now, my learned friend seeks to rely on two cases to suggest that that is not the right analysis. The first is Jerome and Kelly. That will be one of his supplemental authorities. So his bundle that was just handed up to you, tab 4. And it's page 25 at the bottom right. Now, Jerome and Kelly was actually a case about a deeming provision in capital gains trust legislation, but part of the Court of Appeal's reasoning was that actually the property had passed at an earlier date by virtue of the signature of the contract, and the House of Lords disagreed with that way of looking at things. But if you see paragraph 30, there is reference again to the decision in Lysaght and Edwards. And I should say it says a case about the equitable doctrine of conversion. Just to pause there, it's a entirely different doctrine of conversion, which is not helpful to us. This is about, for the purposes of wills, treating
that which ought to be done is done.
Personal property. So quotes again the principle set out there, that the doctrine is that the beneficial ownership passes, and then goes on to refer to the fact that's not ordinary trusteeship. And the real point is in paragraph 32 on page 26 on the bottom right. It would therefore be wrong to treat an uncompleted contract for the sale of land as equivalent to an immediate irrevocable declaration of trust or assignment of beneficial interest in the land. Now, can I just pause there? I completely agree with that. I take no issue with that proposition at all. Plainly, the conclusion of the FSC was not equivalent to a declaration of bare trust, not least because for the next 5 years, Galliard Hotels continued to have a significant interest in the property. But Lord Walker then goes on to say, neither the seller nor the buyer has unqualified beneficial ownership. Beneficial ownership of the land is in a sense split between the seller and buyer on the provisional assumptions that specific performance is available and the contract will in due course be completed if necessary by ordering specific performance. In the meantime, seller is entitled to enjoy the land or rental income and can be falsified by subsequent events. Contract proceeds to completion, equitable interest can be viewed as passing in stages. Now, I take no issue with anything that is said there. Indeed, I positively adopt it. The beneficial ownership is split because Southbank got the beneficial ownership with effect from the date of the FSC. Yes, it is a future interest, as some are, for instance, an interest following a life interest, and it is a contingent interest because it may be falsified if the contract is rescinded or ceases to be capable of specific performance. But the important point is, it is not, as my learned friend suggests, a mere interest, a mere right to bring a claim for specific performance. There is a genuine split of beneficial interest. And that is sufficient for our purposes because it is the beneficial ownership which passed which we are complaining about.
I wonder whether you're right to call it a contingent interest.
I realised as soon as I said it, it was the wrong word.
I think just looking at this passage to say that it's a defeasible interest.
Yes. It's in fact unconditional under this contract. The date on which it will pass is to some extent uncertain, and it is defeasible, although one might say that about a lot of interest, because you can always rescind many contracts. But it is not a contingent interest. It is a vested beneficial interest, but that is to some extent precarious. It is defeasible in limited circumstances, but it is a genuine beneficial interest. The other case, I'm not going to go to it now, I'll deal with it in reply if I need to, is Southern Pacific. Southern Pacific is authority for the proposition that the buyer under one of these contracts cannot convey a proprietary interest to another party. So although we would say the purchaser obtains this beneficial interest of a particular nature under the contract, Southern Pacific says that cannot be, the purchaser cannot grant an interest out of that pending completion of the contract. And again, I don't take issue with that, but I will certainly be submitting, I wait to see what my learned friend says, that it was not in any way casting doubt on the well-established principle that the purchaser nonetheless does have a equitable proprietary interest in the land, and was certainly not in any way suggesting that it was overruling the settled authority going back to Shaw and Foster in 1872. So we submit the true position is as I've described. The purchaser, Southbank here, did have a beneficial interest in the annex on the terms of the freehold sale contract, and that is precisely what was converted because it was those rights which end up in the hands of Lodgeshine. But second, and as a fallback, even if my learned friend was right to say that the nature of the property which Southbank owned was simply an equitable interest entitling it to specific performance of a contract to transfer the entire freehold, including the annex, we would still be right about section 21(1)(b). My learned friend's argument is just another form of the form over substance point. It depends on arguing that the right to specific performance was unaffected by, not converted by, the Annex Lease Scheme. But that is just not a tenable analysis. The position was that before the Annex Lease Scheme, South Bank had a right to compel the transfer of the entire freehold interest to the Annex, unencumbered by any lease. That was its right. After the Annex Lease Scheme, it could only compel a transfer of the legal title, a reversionary freehold interest, which was encumbered by a lease. And the right to enjoy the annex had in fact already gone into Lodgeshine. And so again, if one simply steps back and says, well, has the right, the property that belonged to South Bank been converted to Mr. Conway's own use, having regard to the purpose of Section 21, the answer is yes, because South Bank had a legal right to the entire legal and beneficial interest in the annex, and instead, after the Annex Lease Scheme, all it could get its hands on was a reversionary freehold.
Just thinking around it for a minute, is it crucial to your argument that it was specifically enforceable? I mean, on any view, South Bank had a contractual right. It had a right. And you say, well, that right has been converted to Mr. Conway's use in the way you say. Is it crucial that it was a specifically enforceable right?
So my answer would be no, that you could have a conversion simply of a purely personal right to a transfer of a piece of property. But I accept that that would require a broader reading of Section 21 to cover a situation where the substance of the right has not itself been altered, but its practical enforceability, if I can put it that way, has changed because you can now only claim damages for breach of contract. The advantage of the reason the specific enforceability is a positive feature of this analysis is it means that South Bank did in fact have an interest in the property itself, in the annex.
Yeah.
And you say the situation is analogous to that which was being considered in Englewood Properties in relation to you should, as a vendor, you should ask the purchaser whether or not a lease should be granted, because that's going to affect what they get.
Because that is the trust property. That is the thing in which the beneficial interest has already passed, and all the seller is doing is holding that as a fiduciary steward, subject to its own interests, the lien for unpaid vendors' lien. That then brings me, and I hope I can deal with this before lunch, because I can take them fairly briefly, at the two respondents' notice grounds, and it's probably convenient just to have my learned friend's skeleton out. There it is. It's paragraphs 46 and 47 of his skeleton, and it's probably better for you to have them so that I don't unfairly summarise his arguments. The first argument at paragraph 46 is it said that the grant of the lease was not a conversion by Mr. Conway in his capacity as director of South Bank. Those are the underlined words. Because it is said the lease, because it was a legal lease, could only be granted by the holder of the legal estate, i.e. Galliard Hotels. Now, the fundamental flaw we would suggest with this argument is that there is in fact no requirement that the conversion take place by virtue of an act in a particular capacity. The statute is written in what might be said to be passive form. What is required is that the action is one to recover property which has been converted to the trustees or directors' use. Nothing in the section talks about the capacity in which that is done, Now, of course, as a matter of liability, if there is not a breach of the duty owed to South Bank is not going to have a claim. But there are many things that are done in one capacity but can be a breach of a duty owed to another company. Signing a lease on behalf of Galliard Hotels can be a breach of a duty to avoid conflicts of interest owed to South Bank.
And at some point, we might need to think more about that sort of duty. But anyway, not
Yes,
now.
of course. And ultimately, we say this is just trying to read something into the section that isn't there, and indeed doesn't need to be there to serve the purpose of the section. What is important is, does it result in the thing which the statute is concerned with, i.e. the director coming away with trust property or the benefit of trust property? And one can think of examples of why this doesn't work. Imagine a scenario where a bank holds legal title to shares on their trust for a company. So company buys some shares, but it gets its bank to hold legal title as custodian. Company has absolute beneficial interest. Director of the company then instructs the bank as custodian to transfer legal title in the shares to the director's own company. Now, obviously, there's no difficulty in applying section 21(1)(b) there, even though the actual conveyance, the only transfer of title, has been done by the bank. The bank has transferred legal title to the shares, that has overreached the equitable interest and destroyed it. And the company could never have transferred the legal title to the shares because it didn't own it. But there's no difficulty with applying section 21(1)(b) there. That is still a situation which the director has brought about. And even though he could not himself transfer the property, he has breached his duty and has brought about a situation where the shares have been converted to his own use. So it should not matter who executed the particular legal conveyance that had the effect of transferring the property. It doesn't matter here that Galliard Hotels was the one that signed the lease.
I mean, there is obviously a distinction from your example in the sense that in your example, the director of the company in giving the instruction to the bank will have done so as a director of the company.
He will. And he will have done a positive act in doing that. But why does it make a difference if what the director has done is simply stand by and allow the other company to execute the lease when he ought to be stopping it? So he allows the conversion to take place by failing in breach of his duties to stop it happening. Nothing in the section 21 says you distinguish between a situation where the director's breach was in positive form or in negative form. All that matters is the end result, that there has been a conversion of trust property to the use of the director. And of course, even if I were wrong about that, I would go further and say that in this case, it is totally artificial to say that Mr. Conway was only wearing one hat at the time. True it is, of course, that Mr. Conway had to sign, well, I say he had to sign, of course he didn't sign, but let's assume he did for the moment, had to sign the lease in his own name, in the capacity of Galliard Hotels. But I would suggest that is a rather one-eyed analysis. The lease was part of a coordinated scheme involving a lease and an underlease, the genesis of which was to rentalise the annex. It was always one coordinated scheme. And so it involved Mr. Conway bringing about a composite transaction acting for three companies, acting for Galliard Hotels, Lodgeshine and South Bank. And to say that you regard him as only wearing one hat when signing the lease in particular it is in my submission completely unrealistic. A fortiori, where the respondent's own pleaded case is that South Bank consented to the grant of the lease through Mr Conway. And just so you've seen that, that is core bundle tab 11, page 221. So Roman 5 at the bottom of the page, it is dealing with the hypothesis on which this arises, which indeed we say is the correct hypothesis. But if you then go over the page to numeral 2, South Bank was a party to the underlease and freely entered into it with full knowledge of its terms. As South Bank also knew full well, the underlease was entered into as part and parcel of the transaction involving the lease and underlease. By entering into the underlease in these circumstances, South Bank expressly or impliedly acknowledged the existence and or consented and or represented that it acknowledged the existence and or consented to the lease, Galliard Hotels grant thereof, and Lodgeshine's title thereunder. So my loan print's only case is that this is a single coordinated scheme in which Mr Conway is not only bringing it about on behalf of Galliard Hotels, but consenting to it on the part of South Bank. And he can't then realistically turn around and say, oh, well, sorry, I was only wearing my Galliard Hotels hat at the moment I signed the lease, and therefore wrong capacity section 21(1)(b) doesn't apply.
And that, I think, is 1 o'clock.
It is, and I failed to get through the second limb, but I will do that.
Just so you know where we're going, you obviously lost half an hour first thing this morning.
Yes.
And I'm sorry about that. But we were proposed to make that up by starting at 10 o'clock tomorrow.
Right.
If you've agreed, so to speak, or sort of agreed a day each, I suppose you get the first half hour tomorrow to make up for the lost half hour today.
I will do my best not to need it, but equally, since my junior will be taking the final slot, I don't want to squeeze him. So if we do need it, I'm grateful for that.
2 o'clock.
All right, in April.